everybody. Thank you very much for joining us for this third and final session in the workshop on devolution in the UK and international law. This is our second session on human rights. I'm Conor McCormick, chair of this session and co-host of the three workshops with Jane Rooney, who you've met already. So it's the same format as the previous 2 days. The main presentations will be recorded and shared. And please, if you have any questions or comments for any of the speakers or just in general, type those into the chat bar and I'll pick them up at the end. So 3 presentations, 15 to 20 minutes each, then followed by a PhD discussant who will tell us how their own research relates to the theme of today's session and pose any questions they want to at the start. First speaker is Katie Boyle, who's an associate professor in international human rights law at the University of Stirling. Thank you very much, Katie, for agreeing to give the presentation. And I think at this point, it's probably most efficient in time terms to pass to you, give you the screen. So take it away.
Great, thanks very much. So I'm not working with a PowerPoint just wanted to say, first of all, before starting, thank you so much to the organisers for all their work and bringing us together. It's been a total pleasure to listen to presentations for the past couple of days. And it has given me lots of opportunity to reflect on some of my own thinking around devolution, as well as learn a great deal more about the operation of international law, human rights and devolution in other jurisdictions, not just Scotland. I wanted to speak today very specifically. The talk is based on a short article that I wrote for Edinburgh Law Review, where Chris is public law analysis lead, a few years ago as part of the sort of incorporation discussion that was going on in Scotland at the time. And it's since been slightly updated as developments come through in the past year or so. And so rather than reflecting on the questions that we have about indeterminacy, about whether or not there should be central government intervention when international obligations are not met, and then just to what degree observe and implement is within devolved competence. I think what I'll do is work on the basis that, given that we've had some discussions around observe and implement, and given that that is a power that's devolved to each of the devolved legislators, rather than focus on very specifically the confines of what that means, the talk is working on the basis that devolved legislators can observe and implement international obligations within their spheres of devolved competence, and comes with the caveat, of course, that what is within devolved competence can be subject to debate. And in relation to the discussions around the UNCRC bill, I think I would take probably a more optimistic view of that reference. I suspect that part of that will not be about shutting down the incorporation journey, but clearly outlining how far the maximalist approach that the Scottish Parliament sought to take, how far that can go. And I suspect that the real tests will be around whether or not it's possible for the devolved legislator to introduce legislation which allows the court to strike down Westminster legislation retrospectively in devolved areas if it's incompatible with the UNCRC, and I really think that's probably the point where the devolved legislator could be deemed to have gone too far, and also in relation to the obligations it place on UK ministers. But I think in respect of how the Scottish Parliament has sought to self-regulate within Scotland, within devolved areas, that part won't be so much problematic. So what I'm going to speak about then slightly shifts our direction to not so much about what's within the power of the devolved legislators, but assuming that that devolved power exists to implement and observe international obligations, how to do so in a meaningful, constitutionally feasible way. And so that was part of the remit that was given to the First Minister's Advisory Group that I sat on in relation to human rights leadership for Scotland, and following on from that, the National Task Force panel that looked at incorporation of international human rights law into the devolved context. And I think important to note, and something that I think is often really a key thing to be aware of working as I do in the area of economic, social, cultural rights, is that often you'll have two narratives at play, and the UK discourse is very much set apart in many respects to economic and social rights conversations which exist globally and comparatively. And some of the outright rejection of economic and social rights as legal rights, it now feels like quite an outdated position in terms of how we look at it within our UK discourse. You know, the idea that from the outset we reject the justiciability of those rights doesn't play into the reality of what actually happens day to day in courts, and also doesn't reflect the practice that exists comparatively and internationally. So one of the questions put to I suppose those working in the sphere of whether or not to incorporate international human rights law into devolved law was not so much about whether or not it was possible, but how it could be possible in a meaningful way. Moving on from that outright rejection of justiciability, and in the abstract, I just highlight examples of cases in which economic, social, cultural and environmental rights are adjudicated on in day-to-day court practice. And I think one of the issues is that it's not under a coherent or a sort of comprehensive theoretical framework that currently occurs. So what the question around how to incorporate and make meaningful those rights which are derived from international law, which are not protected by the ECHR, is about doing so that in a way that closes the existing accountability gap, insofar that if international obligations are not incorporated in domestic law, they cannot be relied upon in court. Now, there has been some shifts in that way of thinking, particularly I think really from the McCare case through to Lady Hale's approach. ZH Tanzania was a seminal case that we can use international treaties to interpret our ECHR obligations, so civil and political rights, interpreted in a dynamic way. However, Lord Reid in the most recent case, which has looked at this in SC on the benefit caps case, has been extremely clear, and it's the other line of thinking which is now taking precedence, and judicial reasoning, which is treaties that are not incorporated do not form part of domestic law. So there is a gap there, and the power to close that gap is with devolved legislators. So as I say, it's about reflecting on how that might occur in a way which is feasible. Now, within the field of economic, social and cultural rights, as I mentioned, this is not a novel idea. Countries all around the globe do it. It's not to say that any country has developed a perfect system. There is no panacea, but social constitutionalism or transformative constitutionalism, particularly in the global south, has been really at the vanguard of constitutional developments, thinking, theory and practice. And so there's lots to be learned from that experience, as well as European social democratic constitutionalism and the way that operates. And when you look at the constitutional theory associated with the area, what you'll often see is suggestions that the best way of incorporating rights is to do so on a foundational basis. So rather than just rely on the judiciary or just rely on the legislature or the executive, that ideally all three organs of the state should be guaranteeing human rights to the same degree and holding each of the other to account. So you incorporate and embed across those arms of state. And so rather than just focus on accountability mechanisms and access to justice via court adjudication, what you should be looking at is how to encourage accountability mechanisms across those arms. And of course, there's also the fourth branch, which is to look at ombudsmen, regulators, tribunals, and those that can operate in the accountability sphere within the decision-making zone. And reflecting on that multi-institutional model of incorporation, we can learn a great deal in terms of looking at existing practices and whether or not they meet those normative standards. Now, second to that, within very specifically the field of economic, social and cultural rights, you'll also encounter what I would call waves of critiques. And really what happens, and quite often what happens in countries which are for the first time looking at whether or not to incorporate or embed these types of rights into domestic law, and incorporation can happen in many different ways. It might be with reference to the international treaty itself, so Norway uses that model, for example, the ECHR Human Rights Act is an example of that, or you may see just a domestication of international norms. So the South African constitution, for example, has that. The Finnish constitution, you'll see essentially what exists as international obligations are given domestic meaning through either the constitution itself or a constitutionalizing act. So when you look at the incorporation of economic, social and cultural rights, as I mentioned, you face various critiques. And the way to try and overcome those critiques is to, first of all, take them seriously, because they do raise important concerns around democratic legitimacy. And the four that are most prominent in relation to further incorporation of rights is that, first of all, if you seek to do so in a way which affords the courts an important role in determining those rights, particularly if they're polycentric in nature, it can be anti-democratic. And so there's a fear that incorporation suddenly hands over the reins of decision making to unelected judges, and it's an important critique to bear in mind. But responses to that critique also tell us that if you have a multi-institutional model of incorporation, what you seek to do is create a more accountable, deliberative decision-making framework in which the court is one actor of many that can give meaning and substance to rights. So the legislator has a responsibility to take steps, the executive, the government, has a responsibility to fulfil rights, and ultimately the court is there as a means of last resort. So rather than frame that as handing over power, Mark Tushnet, for example, speaks about it in the context of ensuring that the court does not abdicate its role in its part in giving meaning and content to rights. And so it helps to frame that more in terms of democratic dialogue. And many of the principles that I've developed in relation to research looks at this area is to use deliberative democracy theory or develop principles derived from deliberative democracy theory to help address the critiques in relation to economic and social rights adjudication. The second critique is that, and what is why I find it so fascinating that came out as part of the questions that were given to us prior to the workshop, it's the indeterminacy critique, that ultimately these rights and international law more broadly suffers from vagueness, that it's indeterminate in its nature. And rather than being able to rely on that framework, we may open up problems with giving meaning and content to those rights, but not dissimilar to the responses to the anti-democratic critique. Others would argue, saying that actually, again, it's for different actors in dialogue to seek to give meaning and content to rights. And when you look at the economic and social rights discussions, the literature and practice around this, what you'll often see is that there's a recognition that civil and political rights aren't necessarily determinate in nature. They have required different actors to work together to give greater meaning to those rights. Treaties in general will require different actors to give meaning, and in the context of the international human rights framework, often what you'll see is that the framework is a framework for decision-making processes around giving meaning and content to rights. So, for example, in the context of the minimum core obligations which exist in relation to economic and social rights, you'll see that what's recommended is participatory processes within the state itself to explain what that right should mean in the prevailing circumstances that exist. And there are competing conceptions of what that means in practice, but it's the process itself which helps to address the indeterminacy. The third critique is incapacity, that the courts would lack capacity to adjudicate rights, and that we don't have the mechanisms through which to handle a constitutionalisation or incorporation of rights beyond, in the UK context, beyond ECHR rights. And again, this responses to that critique would suggest that, well, actually, perhaps it would be more appropriate to look at the efficacy of our existing access to justice mechanisms, and also in relation to the outcomes of those processes. So with any constitutionalisation process, what you'll often see is that there is a shift in terms of legal culture and also in terms of decision making. And incorporation across the branches of government should be operating in such a way as to prevent courts being overrun with cases. But in any event, all other remedies ought to be exhausted first in the court as a means of last resort. And importantly, that leads on to the last critique, which is fundamental to this particular field, which is often what you'll see with rights which are economic, social, cultural or environmental in nature, is that they will be systemic violations. So it won't just apply to one person. Often what will happen is that you will have a systemic issue which affects many different people. And one of the critiques then associated with that is that courts in particular can act as pro-hegemonic exercises of power, that they would, if they were looking at these cases, create greater inequity in terms of distribution of resources, particularly around the way that it operates in relation to things like healthcare, education, housing and so on. And that was the experience in some parts of South America, including Colombia and Brazil. But a response to that critique, again, is about trying to address the mechanisms through which that happens and how access to justice ought to operate through having a counter-majoritarian form of adjudication, or allowing for public interest litigation to flourish, or ensuring that individuals are not left with the burden of raising cases, but there's another way to enable collective cases and collective accountability mechanisms. So those are the critiques, and the responses to the critiques are really important in the context of ensuring adjudication, and that it ought to happen across that multi-institutional framework. So rather than just focus on just one arm of government or just on the court, the way of essentially trying to constitutionalise or incorporate or give a domestic meaning to international norms is to do so in a way that operates across those branches and responds to the critiques. And that is perhaps a helpful way of looking at the way that other or examples of incorporation processes are currently operating. So rather than think about it from the perspective of the practitioner or the judge or the scholar or so on, if you think about it from the perspective of the rights holder themselves, the main question for me is to ask, if a violation of this particular rights occur, is there a mechanism through which they can reach an effective remedy? And that sort of gives you the beginning and end of the journey, and the part in the middle is the part that needs to be worked out, which of course is much easier said than done. But we do have examples of that through the Human Rights Act, through the Devolved statutes, and what you see with the UNCRC bill is basically a model which draws from the Scotland Act and the Human Rights Act in order to create a framework where you can have an effective remedy, and they do include the word effective within the bill itself for a violation of the right. But where it might be lacking, for example, is if you look at how the pre-legislative scrutiny mechanisms, they are not particularly strong. There are some examples of obligations on decision makers and through child rights schemes and so on, but it doesn't include the type of internalisation or integration into decision making that might be necessary, nor are the participatory processes fully developed out in terms of giving meaning and content to rights beyond what the treaty itself says. And it may ultimately suffer from the fact that it's a redacted version of the treaty, not the full treaty, which causes problems in relation to the indivisibility of rights. The second process of incorporation in Scotland, which relates more closely to the National Task Force, attempts to go further than the UNCRC model, but not in terms of reaching into more areas which are touching on reserved or seeking to impose obligations on UK ministers or the UK legislature. Its a more comprehensive approach to incorporation seeks to try and internalise or have a domestication of international legal standards, such as, for example, working on the basis that there would need to be greater pre-legislative scrutiny of compliance, and using the Finnish model as an example of how might that operate in practice, having greater participative processes associated with giving meaning and content to rights, including working out what is meant by minimum core obligations, as well as progressive realisation, stronger access to justice mechanisms. For example, working on the basis that there's a recognition that systemic issues may need a different type of response, And so we see reference to the use, for example, of structural remedies, which is where a lot of the sort of most recent literature and practice is focusing in terms of transformative constitutionalism, and also trying to overcome some of the hurdles associated with the privatisation of public services. Now, what the UNCRC bill has achieved is that it got unanimous backing from the Parliament, has been passed, and now we await the outcome of the Supreme Court to see where those litmus tests are. What will happen with the multi-treaty bill is yet to be determined, because at the moment that is shelved as we await future plans of the Scottish Government in terms of bringing that bill before Parliament. But importantly, as I say, it tries to embed and incorporate in a more expansive version. So I've come to 20 minutes and I'll close there, and thank you very much.
My paper is about the relationship between devolution and the international monitoring mechanism. So it's not about adjudication or litigation. It's about evaluating at a quasi-judicial or quasi-political level sometimes the performance of states in complying with their international obligations. So it's covering, for the purposes of this paper and for the larger study of which this paper is a part, I should say the larger study is about the impact of all the international monitoring mechanisms that the UK has engaged in over the years on human rights on the ground in the UK. What difference have all these mechanisms made over the years, and in particular since the year 2000, which coincidentally is pretty much when devolution kicked in throughout the UK. So I'm looking at the well-known UN and Council of Europe monitoring mechanisms, especially the treaty-based ones at the UN, but also the charter-based one, the Universal Periodic Review. And I'm also looking for the purposes of the larger study at the monitoring which is carried out on a kind of ad hoc basis by special rapporteurs and working groups, etc. In my paper, I tried to give an oversight of an overview of the range of mechanisms that are currently in place. That if you count up the UN and Council of Europe ones, there are basically 20 of them. 12 UN and 8 Council of Europe ones, and the UK has engaged with 17 of those, so 10 of the UN ones and 7 of the Council of Europe ones. And they go way back. These are not just post Second World War mechanisms. The one that's been conducted by the International Labour Organization started in 1926 and carries on almost to the neglect of human rights scholars. I think it's very hard to find academic work based around the monitoring conducted by the Committee on the Enforcement of, I can't even remember the acronym now, the committee at the ILO, which looks at the enforcement of the conventions and recommendations issued in relation to ILO conventions. So states have been reporting almost annually on their adherence to those conventions since 1926. And there are now 8 fundamental rights conventions within the ILO's huge panoply of conventions. So this monitoring goes back a long way. For the purposes of this paper, I thought I would look at the most recent operation of each of the 17 evaluative mechanisms, which have all occurred obviously in the last few years. If we go back to the year 2000, as table 2 of my paper reveals, there's a total of no fewer than 140 evaluations that have been conducted vis-a-vis the UK. Now, almost exactly half of those are the ILO evaluations. But if we take those away, there are still 71 evaluations conducted by the other UN mechanisms and the Council of Europe mechanisms. In fact, the majority of them are Council of Europe evaluations. There are 45 from that source and 26 from the UN. So what I've done for the purposes of this paper is look at the most recent instantiation of each of those 17 mechanisms, including, despite what I say in footnote 9 of the paper, including the evaluation conducted by the subcommittee on the prevention of torture run by the UN, by UNCAT. Although that report is not yet published, I have seen an unpublished version of it. Anyway, it's quite a lot of documentation to look at, and all I can do really for the purposes of this paper is to draw out some kind of high-level conclusions, thoughts, really observations based on what I've been reading. The first of those is that, by and large, the UK government does provide in its national reports to all of these mechanisms quite a bit of information about the devolved regions. It tends to emphasize the good things, the positive points, and not highlight the respects in which the devolved regions may not be meeting the international standards. And of course, the fact that for many of these mechanisms, especially the UPR, the Human Rights Committee of dealing with the Civil and Political Rights Covenant, and the Committee on Economic, Social and Cultural Rights at the UN, they cover a wide range of rights, and it's difficult in a national report to say much about all of those rights and about how they've all been protected in various ways within the different jurisdictions of the UK. And that's a problem because, as well, the UN places word limits on the national reports that can be submitted and on the concluding observations that are then issued by the monitoring committees. So there's a built-in limitation to the effectiveness, if you like, of the monitoring in terms of the documentation produced. Coupled with that is the effect of the principle of state equality that operates at the UN and Council of Europe level. So every state is given the same amount of attention by the monitoring committees, regardless of the size of the state or whether the state has lots of sub-entities, whether it be a federal state or a state which is unitary like the UK but has different jurisdictions within it. So all of that, I think, militates against devolved regions from the UK getting any kind of attention really at either the UN or the Council of Europe. It's slightly better whenever the mechanism involves not just or not even perhaps a face-to-face dialogue with the members of the committee, such as we find in Geneva with all the UN committees. That they place a great emphasis on the importance of the dialogue that takes place between state representatives and members of the committee. Whereas the Council of Europe, they rely a bit more on visits to the states. So obviously the Committee on the Convention for the Prevention of Torture, the Committee on the ECRI Committee, Commission for Racial Intolerance, or Against Racial Intolerance, the Advisory Committee for the Framework Convention on National Minorities, the Committee on Languages, the Committee on Human Trafficking, Greta. All of those committees visit the UK, and that gives them a better opportunity to interact with devolved regions. So sometimes the Committee on the Prevention of Torture has a visit just to Northern Ireland or just to Scotland to look at the condition that prisoners and other detainees are facing in those jurisdictions. That kind of focus on a region isn't really possible through the UN systems where the face-to-face dialogue takes place in Geneva. The second high-level observation is that despite the greater focus by the UK government on the devolved regions since 2000, there still are inconsistencies and inefficiencies in the way that that information is gathered from the regions and presented to the monitoring mechanisms. As has been pointed out, I think, at least indirectly in some of the papers for this workshop already, Scotland leads the way in this. The Scottish government has been much more proactive than those in Wales and Northern Ireland in supplying information to the monitoring mechanisms. And if you look at the documentation resulting from the Universal Periodic Review, the latest of which was in 2017, you'll see that a great number of responses are provided by the Scottish government through the UK government on human rights issues relating to Scotland, and many more so than would be the case for Wales and Northern Ireland. And the fact that in Northern Ireland there were no government ministers in place from 2002 to 2007 and from 2017 to 2020 led to a great deficit in information being supplied to some of the mechanisms. And the Northern Ireland office refused to step in to provide that information, perhaps because it itself couldn't obtain it from the civil servants in Belfast. Likewise, the quality of consultation between the devolved administrations and the civil society organisations and the national human rights institutions remains variable across the regions. And I think there's less proactive engagement by the civil society organisations and NHRIs than there should be, in particular in the area of economic and social rights that Katie has just been talking about. There's a bit of a deficit there. The Equality and Human Rights Commission in London has a unit that looks at the international monitoring mechanisms, but it pays virtually no attention to the Economic Committee on Social Rights operated by the Council of Europe. It doesn't do anything about the ILO conventions. And in fact, getting any information from the Equality and Human Rights Commission about the details of their interaction with government officials on this kind of monitoring is extremely difficult. I'm going to have to put in an FOI request, I think, because to date I've been refused access to any of the minutes of the meetings of this unit at which there are senior government officials. My third point would be that the monitoring bodies themselves, especially at the UN, tend to adopt a very state-centric approach to their monitoring. For example, they often insist upon a national strategy being adopted, regardless of the fact that at a sub-state level there are strategies already in place to deal with the protection of human rights. I think that's a defect. Sometimes representatives from Scotland, Wales and Northern Ireland do attend at Geneva whenever there are these face-to-face dialogues with officials and between officials and the monitoring bodies. But they're very, very much outnumbered by London-based officials, and there just isn't a degree of interaction between the monitoring bodies and the devolved regions that there should be. Fourthly, I don't think the devolved administrations pay enough attention to the dissemination of the concluding observations of the monitoring bodies, or make enough effort to consult with the civil society organisations and NHRIs on how to implement recommendations. Certainly in Northern Ireland, there's no clear strategy on this issue, and Katie can correct me on this, but it seems to me that the Scottish focus at the moment seems to be almost exclusively on the incorporation aspect of the treaties. You know, that's the whole thrust of the development in Scotland, and that's great. But I'm and I know that there are some developments, and it's part of my fifth point actually, in trying to get the Scottish Parliament to get itself more involved with the oversight mechanisms, and that's well and good. But that's doesn't seem to me to have the high profile that the incorporation strategy has. And as regards Wales and Northern Ireland, that kind of involvement at the parliamentary level or assembly level is almost non-existent, I'm afraid to say. My sixth point is that the Northern Ireland Human Rights Commission has, I think, been the most effective, or the most active, I should say, of the three UK NHRIs in this context. In the last 20 years, it has made 61 submissions to the international monitoring mechanisms, including to 2 UN special rapporteurs. The Scottish Human Rights Commission has been engaged with the UN's Universal Periodic Review and with 7 of the UN treaty bodies. But no NHRI, as far as I can see, has interacted meaningfully, again, with the ILO or with the Council of Europe's Economic Committee on Social Rights. So again, social and economic rights are the poor relation in this context. Now, having said all of that, my seventh point would be that Northern Ireland in particular has attracted probably a disproportionately greater amount of attention at the monitoring mechanisms than either Scotland or Wales. The most prominent issues being the decriminalisation of abortion, accountability for conflict-related violations, the mistreatment of children in residential institutions and also by paramilitary groups, and the absence of any Unified Equality Act, such as there exists in England, Scotland and Wales. So I mean, overall, it's difficult, I would say, to sum up, it's difficult to point to any particular positive change in human rights on the ground in any of the devolved regions that is directly attributable to the operation of the monitoring mechanisms taken in their purest form. The big exception, you might argue, is the decriminalisation of abortion, which Jane talked about on Monday, and it's obvious that CEDAW played a huge role in that as a result of the inquiry it conducted into that issue. So it didn't result, well, you might argue that the inquiry itself resulted from the monitoring that CEDAW was conducting, but it wasn't the monitoring so much as the inquiry which led to the intervention in Westminster and the subsequent legislation. As in all of these matters, it's difficult to prove cause and effect. I'm not arguing that the monitoring mechanisms are ineffective. They are very effective and impactful in all sorts of ways, not least in raising the awareness of the importance of human rights within the government, within civil society, and on the ground, really. And lots of people have been prevented from suffering human rights abuses because the state has stepped up to the plate and met its international obligations as a result of, or in order to comply with, the international standards. So it's difficult to prove direct cause and effect, but I don't want you don't want to stop by leaving you with the idea that I don't think the international monitoring mechanisms are effective or successful. They are, but they still can be improved in all sorts of ways, especially as regards the devolved regions. So I'll stop there. Conor, thank you.
So, Vinny.
Are you okay?
Good to go.
Great, thank you. Thank you. Technical aspects, always challenging for me, despite a year of teaching time. So thanks to Dr. Boyle and Professor Brice Dickson. It's really useful to go after those, as you mentioned, Conor, those broad studies to look more in detail at this monitoring mechanism. And I hope there's some synergies and some talking points which we can read across from those. So Hayley will go more into detail about where this project came from. But in essence, it highlights some of the intergovernmental relations issues and interparliamentary relation issues, which we've touched upon over the last couple of days. And maybe neither Hayley and I are experts in children's rights, but I think this is the case study which is most appropriate from a Welsh context. And the reason for that, I think, is the commitment that the Assembly in its early days showed towards children's rights and towards the UN Convention on the Rights of the Child as well. So early in the century, child abuse cases, some scandals in schools were quite high profile in Wales. And this led to a number of inquiries, like the Clwch inquiry and child accommodation places in North Wales as well. So children's rights has always been at the centre of the work of the Assembly. And it's also been seen by the Assembly as something where they can take a lead and where they could be an international player or be a flagship for their proposals and show that Wales is acting in a progressive and in an internationally leading way. So incorporating or giving further effect to the UN Convention on Rights of the Child is a real feather in the cap for the National Assembly. But if we just track it a bit further back, even since 2004, so remember the period before the National Assembly had legislative competence, as Joe outlined yesterday, the UNCSC was adopted as an underpinning basis for policies on children and young people. So there was already a commitment to follow the convention and make that quite explicit in terms of the policies followed by the Welsh government, the Welsh Assembly government at the time. Now, with the strong support of non-governmental organisations and civil society, this ultimately led towards the incorporation of the CSE into Welsh law through the Rights of Children and Young People Wales Measure 2011. So children's rights is useful from this perspective, but also shows us that the journey of devolution, or the process of devolution, has been, the children's rights has always been there and always been right at the forefront of the measure power and the full legislative power later on. So the measure is quite short, but in its preamble says, a measure to make provision for and in connection with giving further effect in Wales to the rights and obligations set out in the UNCSC and for connected purposes. And the key duty in the measure is that the Welsh ministers must have due regard when exercising any of their functions to the UNCSC and the protocols ratified by the UK government. So the due regard issue is something which touched on a few days ago, something we might come back on, but we want to focus on the monitoring more specifically in this presentation. Then there are other duties on Welsh ministers, that they should prepare a children's scheme, that they should report periodically to the Senedd on their children's scheme and on their commitments to the convention. And lastly, something we see quite often in Welsh legislation is the need to promote knowledge of the UNCSC among young people and the population in Wales. So we see that the commitment has always been there in the early days of devolution, through the measure-making power, through the creation of the Children's Commissioner for Wales. We see it more recently in terms of removing the defence of reasonable chastisement against children and the creation of the Youth Parliament in Wales. But that doesn't mean that there's still gaps in, if you come to some of the key questions of the conference in terms of competence. So The Senedd won't be able to make any changes in terms of legal aid or the justice system, such as children's imprisonment in Wales, and it also can't touch on aspects of benefits, national insurance and so on. So it's an useful case study from the perspective of competence, but also from the perspective of Wales being wanted to be seen as an international player, an international leader, or especially within the UK, of the convention rights, but to what extent it can do that within its competence is more challenging. So we touched briefly on the Memorandum of Understanding in a couple of presentations earlier, but I think it's worth just highlighting the key ones in terms of monitoring and the Concordat on international relations. So as we know, the UK is the states party, is responsible for reporting and monitoring, and the buck stops with it. And I think that's an important point, that it has the control. And the Concordat, as we know, as with other intergovernmental relations mechanisms, the UK government is in control. So international relations are the responsibility of the UK government, but devolved governments have an interest in implementing international obligations and the responsibility to implement international obligations that specifically cover devolved matters. And then it leaves quite a lot of room for UK ministers to decide what the involvement of devolved governments should be. So UK government will invite the devolved nation or devolved government to contribute to reports to international organisations when reporting on compliance, and will consider representation when international organisations discuss these compliance reports. So it gives quite a lot of room in terms of the discretion that UK ministers want to give proposals and reforms in devolved nations. And lastly, as Professor Dickson has pointed out, monitoring is usually on a 5-year cycle in terms of the UN Convention on the Rights of the Child. The last monitoring process was in 2015-16. It's currently working on the next reporting process, which is a simplified reporting process, which we might touch on again at the end, which might have some implications. So that gives the background. I think Hayley is going to talk a bit more about the project itself.
So really, in addition to the UNCSE being a really good case study for monitoring from the context that here was provided, we were seeing a lot of social media posts at the time suggesting there could be problems in the procedure, or at least there was a lot of unhappiness around Wales's and the rest of the devolved countries' involvement in the reporting and monitoring procedure. So I've just screenshotted a few tweets here from Sally Holland, who's the Children's Commissioner for Wales. She's disappointed that Wales wasn't mentioned at all by the UK government on 2 major devolved policy areas, education and social care. There's another quote from her saying, the Welsh Government gets the first chance to speak towards the end of the hearing. So there was a lot of monitoring about when were the devolved government officials were allowed to interject into proceedings. Matt Walker, I think, was an attendee at the session, and he was part of a group that had submitted a youth report. So he was tweeting from Geneva a little bit more strongly, it seems, than Sally Holland, saying replies to the Committee on Sex Education, matters relating to PSE are only coming from England, where is devolution? A disproportionate amount of responses from England only today and yesterday, that the devolved nations should get some equal footing. He suggests that the fact that the question on mental health waiting times in devolved nations was answered by an England, or what he calls an England representative, is terrible. We also have one from Northern Ireland that we picked up on, that the UK delegation's unable to make a comment on any waiting times for mental health provisions in Northern Ireland. And finally, I think that was a campaign for a youth parliament assembly. Again, I'm taking, following Professor Dickson, struggling with the acronyms here, but it's about the youth parliament, and hearing lots of responses from the UK government this morning on alternative care and family support relating only to England. And again, lots of talk about just NHS England, so rather than Wales. So a lot of this going on at the time, which together with the context made us think that this could be a really good project to have a look at. Diolch. Great. So looking at the UNCSE project itself, we wanted to examine Wales's involvement in the monitoring process, and it was a good opportunity to do so, and then to identify any impact and broader context of that involvement. So in terms of impact, we considered that it could have an immediate impact, such as the impact it could have on children's rights if the concluding observations weren't as strong as they could have been because Wales's involvement wasn't as strong as it could have been. If that was an issue at all, we wanted to explore that a little more. And also the broader context of the involvement. So if the involvement does turn out to be problematic and there are challenges, is that a one-off that just relates to the UNCSE monitoring process? Or is it a symptom of a bigger problem? Is it something that we see throughout all the monitoring procedures? And is it something that we see beyond that? Could it be indicative of broader issues in intergovernmental relations? Which seems like a little bit of a stretch from one particular case study, but from hearing papers over the past 3 days, I think that it's not too much of a stretch to make either. I think it's what we've all been hearing. So it could be indicative of broader issues with intergovernmental relations when it comes to the role of devolved nations in international law. So in looking at this, it's really useful here to hear from Professor Dickson, who looked at it from really a macro perspective and then to drill down to it into a micro in this particular case study. So we looked at the draft and final state party report submitted by the UK, the dialogue session in Geneva, concluding observations. We interviewed some NGOs and other attendees that were in Geneva. And we also looked at other correspondence information. So things like the Joint Committee on Human Rights, they started an inquiry into children's rights just after the monitoring procedure, but it was never finished. The session ended and it was never picked back up, which was disappointing. But we really wanted to focus on the state and the state reports and their involvement, so to speak. So we didn't look at so much at any NGO reports. So what did we find? The next few slides give a really brief summary into some of the key findings, and I think they probably echo what Professor Dickson said in the previous paper, and they give examples or evidence of some of these findings. So the first two is that the final state party report, while it was more robust than earlier versions, it did misrepresent specific England or England and Wales matters as being UK-wide. And although it is fair to say that the committee, as I mentioned, would also receive reports from NGOs, civil society and so on, we were just focusing on the state reports here. And secondly, at Geneva, the UK delegation was really unfairly balanced, which we saw a lot in some of those tweets as well. So to look at the examples of this, so we have Tam Bailey, the Scottish Children's Commissioner, saying there were times when the evidence tended to focus on English matters. There were many more representatives from England, and this may have had a bearing. Sally Holland for Wales, the UN Committee's careful treatment of the devolved constitutional arrangement of the UK state party was not matched with a proportionate delegation against this arrangement. Same from the Coolad, the Northern Irish Commissioner, that she was disappointed at the limited information on the implementation of the UNCSC in the draft report and during the examination itself. And while there had been some meaningful engagement in some areas, it wasn't uniform across all jurisdictions. And then one NGO representative that we interviewed that we kept anonymous. I do remember having the view that when the state report came out, that it was Whitehall dominated. When it comes to the state party hearing, and you've seen the transcript, I mean, it was absolutely bonkers. It was very frustrating watching that. So we are seeing that while the written report was better than the draft, it still continued. It could have been better. But when we get to the oral evidence session, I think that's when things really, or the disparity can really be seen, and that might come from the unbalanced delegation. So 83% of the delegation was from the UK government, or as you saw in some of the tweets, England, so to speak, which was 19 out of 23, and 30% was from the Department for Education alone. So we had 2 representatives from Northern Ireland, 1 from Wales and 1 from Scotland. So out of the 23 that went to Geneva. And on the second slide, got our 2 other summary findings. So 3, we found that in looking at the replies itself, replies to the committee questions were disproportionately England focused. And fourthly, and perhaps a little bit more worryingly, that the UK delegation appeared to be ill-informed as to the breakdown responsibilities between UK and devolved institutions. So just to give a couple more examples, when the committee asked a question about SEND, special educational needs, the UK delegation gave the committee an overview of the important reform to system on children with special educational needs and disabilities introduced by the Children and Families Act. But the response didn't mention that Part 3 of that Act, which applies to special educational needs, only applies to England, as of course SEND policy would, SEND policy and provision is a devolved matter, and so very little information was given on SEND in Northern Ireland, Wales and Scotland generally. On a question on bullying, it was noted how the government, without mentioning which government, had recently changed the law to strengthen teachers' powers to discipline children, had issued guidance on the use of seclusion rooms, how schools are held to account by Ofsted inspectors. So Ofsted is mentioned quite a few times throughout the evidence as giving examples of really good practice, monitoring policies, holding schools to account. But the body obviously only relates to England. Estyn in Wales and the counterparts in Scotland and Northern Ireland weren't mentioned at all during the evidence, so that there wasn't any qualification for that answer. And as to the sort of being a misunderstanding perhaps of the breakdown responsibilities, the committee asked a question on S4C, which is the Welsh language channel, where budgetary cuts were being made, and so children's programmes were in Welsh were being discontinued. That question was given to the chair of the UK delegation, and they fielded that question to the Welsh government representative. But broadcasting is a non-devolved area, and so the budgetary cuts were the decision of the UK government. And the Welsh official did point this out. However, sort of the question passed, and it was the answer was a bit lackluster, and they didn't go back to it. So what do these findings suggest? I'll try to keep these slides really brief. I'll just give a quick summary because I know that we are heading to time. The findings really suggest that there needs to be a robust, comprehensive reporting procedure in the UK, and I'm only mentioning in the UK because I know that Professor Dickson has identified some issues on the other side of the coin, as it were. So there seems to be roadblocks from all areas when it comes to devolved nations participation. But the obligation to make sure that this happens in the UK lies with the state party. So we'd want to make sure that such a procedure, if we were to suggest anything, would be things like closer cooperation with the devolved administrations and governments when it comes to producing that report, making sure it's composed of a balanced number, which might not mean an equal number, but that should be balanced at least, that there should be some divergence in the committee responses. If they're just talking about the UK government or policy as it relates to England, then they should be a little bit clearer with that. And making sure that whoever goes and presents the evidence, whichever country they're from, they need to have a full understanding of the division of responsibilities. And we are coming up to the last 2 slides now. So in looking if it's a symptom of a bigger problem in terms of representation, we saw, and we haven't done any significant research on any other procedures, but just picked this up from the Committee on the Covenant on Economic and Social Cultural Rights in 2016, that they were quite strong in coming down on the UK government and saying that the absence of anybody from the government in Northern Ireland didn't allow it to make a full assessment of the enjoyment of covenant rights in Northern Ireland, and reminded the state party of its ultimate responsibilities in that respect. In terms of representation within the UK, perhaps, the Joint Committee on Human Rights, after the monitoring process, arranged an evidence session with the Children's Commissioner for England and the GB Equality and Human Rights Commission, but they just wrote to the other, the devolved nations commissioners and asked them to write in their evidence. And the Northern Irish Children's Commissioner did suggest quite strongly holding a comprehensive evidence session with all children's commissioners, but also perhaps the understanding of devolved matters within the UK needs some work. So in the letter inviting the Children's Commissioner to contribute, Harriet Harman, the chair of the Joint Committee, had asked Coola to provide any issues for children in Northern Ireland with the Children and Social Work Bill, but she had to respond, well, that bill only extends to England and Wales, so I have no comments in relation to that. So, I mean, she could have had some comments to make, but I think her answer says quite a lot there. And a lot more broadly has been discussed over the past few days, particularly yesterday, the extent of the involvement of other devolved nations in other international issues like Brexit and COVID. So even though this is just one small case study, it might be indicative, or it might be a symptom of a bigger problem.
And just to conclude, I think there's some broader things we could look deeper at, which might be indicative from this case study. So firstly, who controls the narrative? The UK government can control the state reports, the oral evidence, give the narrative that they want, but there's also a counter narrative that the devolved governments have sometimes highlighted issues which they want the UK government to change, like universal credits and so on, that they want to get on the agenda. Do they have the opportunity to do that? Second is the issue of representation, particularly in the oral hearings, and how devolved governments are involved in that process. And then thirdly, which Hayley highlighted towards the end, is the scrutiny of the reporting process. So the Joint Committee on Human Rights started a scrutiny process, but is there a role for a more parliamentary scrutiny and process there, which we've seen more of following Brexit? And then lastly, more broadly, the next reporting process is a simplified reporting process. So maybe some of the structural issues that Professor Dickson was highlighting is further constrained in this process, which might marginalise devolved governments further. But we can't come to a conclusion yet on that. It might be improved. It might be more more representation there. So thank you for your time, and thanks for the opportunity to present.